Welcome. My name is Jason Thomas. On behalf of Deborah Buford, Acting Deputy Associate Director of Partnership and Labor Relations here at the U.S. Office of Personnel Management, I am pleased to open this roundtable and introduce our speaker. Our office presents roundtables in support of our ongoing effort to bring relevant and reliable developmental opportunities to federal sector employee and labor relations practitioners. It gives me great pleasure to welcome you to today's roundtable entitled Case Law Update and Practical Discussion on Disability Law and Reasonable Accommodation. Today's presentation will provide expert knowledge and an in-depth look at disability law, along with a closer look at typical reasonable accommodations such as telework, leave, reassignment, job restructuring, and technology. Under the law, agencies must provide reasonable accommodation to qualified employees or applicants with disabilities, unless doing so would cause undue hardship. Therefore, this roundtable will discuss specific reasonable accommodation procedures, analyze reasonable accommodation issues when handling misconduct and performance, and address cases that involve medical inability to perform. Furthermore, Mark will examine recent case law that addresses disability law, stressing valuable takeaways related to this challenging topic. We encourage everyone to make the most of this roundtable, including asking questions of our presenters. You may do so by sending an email to employeeaccountability@opm.gov. We will do our best to field as many questions as possible. Please note that shortly following the presentation, everyone who registered will receive a hyperlink to an online evaluation form courtesy of surveymonkey.com. Simply click the link, follow the instructions, and your valuable instant feedback will be sent back to us. Your feedback is important to us and helps us plan future roundtables. Mark Maxson currently serves as a member of the Senior Executive Service as the Assistant General Counsel for Administration at the U.S. Nuclear Regulatory Commission. He has over 30 years' experience in federal sector employment law, addressing critical issues involving a wide variety of workplace issues. His work involves supervising lawyers litigating before U.S. federal courts. Mark previously served as counsel for labor relations at the U.S. Department of Labor. He is an adjunct professor in the Key Executive Program and serves as Commissioner of the Montgomery County Commission on People with Disabilities. We are delighted to have Mark as our presenter today to share his expertise in this subject area. Please join me in welcoming Mark Maxson.
Thank you, everybody. I am honored to have the opportunity to speak to you about this critical issue involving reasonable accommodation and disability law. First, to clarify where I come from, having represented agencies, as I currently do, at the Nuclear Regulatory Commission, and also serving as, or prior to my experience serving as the chairman of Montgomery County Commission on People with Disabilities. It's my interest to provide a balanced and understandable presentation about the area of disability law and reasonable accommodation. Next slide, please. So the purpose of the disability law is to demonstrate that people with disabilities, with reasonable accommodations, are capable of performing the essential functions of their job or otherwise enjoy the benefits and privileges of the workplace. I start by citing to you probably the most well-known case, which is School Board of Nassau County versus R-Line. There you had an individual who suffered from tuberculosis, and in that condition she was a teacher, and it was felt she could not perform her job. The agency or the school board fired her, but they assumed that the type of tuberculosis she had made her contagious, where in fact the medical evidence did not demonstrate that. So in essence, it showed that sometimes that the accumulated myths and fears associated with a medical condition can be far more limiting than the medical condition itself, and that individuals should make decisions based on sound medical judgment. In reviewing any kind of disability action, it's appropriate to consider at least in my view, that depending on accommodations, extraordinary things can happen in the workplace. That in essence, the blind can have vision, the deaf can listen, the speechless can have a voice, that those without arms can lift us up, and those without legs can move us, and the press can progress and achieve. That we must understand, however, that reasonable accommodation is exactly that, only that which provides a reasonable opportunity to improve, a reasonable opportunity to perform the essential functions of the job. Next slide, please. So, tracking on the case of School Board of Nassau County versus R-Line, I want to start with a new case. It's not actually in your handout materials, and by the way, those materials of the cases were put out by Lorraine Baer on my staff and Kayla Gaiman, so I'd really appreciate their work on this. But at any rate, in this case, I'd like to discuss with you the case of Matilda M. versus Colin Colvin. So this is what I like to refer to as the Crown of Thorns case. It's January 17, 2017, so it has just recently been released. And in that case, you had an individual who suffered from a mental illness, but she also, because of religious reasons, had a crown of thorns, which was a symbol of Jesus' suffering, on her desk. The case, however, did not turn on religious issues when the crown was expected to be taken away and ordered to be taken away by the supervisor, rather on disability issues. And the reason why that is because the individual had suffered from a mental illness. It doesn't clarify exactly what it is. And the supervisor described her as unstable, and then went on to say that there were a number of people who indicated that she could cause injury and fear in the workplace. The crown itself had little thorns on it, or it was theoretically sharp edges, and so suddenly, because this individual had thorns on the crown, it was thought she could be dangerous. The EEOC found that there was no evidence that she was dangerous. In fact, that the order to have the crown removed resulted from nothing other than the factor of the agency's wholly unsubstantiated perception that the complainant might use the crown as a weapon. And so she was able to receive compensatory damages. It's important for us to realize that when we make decisions about an individual's disability, they must be based on sound medical evidence rather than on our biases and perceptions about whether somebody has a medical condition and to what extent it might affect the workplace. Next slide, please. So I have provided this presentation on 3 or 4 separate times, and as you'll see in the back, there are YouTube videos with earlier versions of what I have done and presented in the past. This one, I am not going to spend too much time discussing the definition of disability for the predominant reason that the definition of disability is discussed in more detail previously in other videos. But here, the ADA, Americans with Disabilities Amendments Act, was passed in 2009, and as a result, it made it much, much easier to prove that someone was an individual with a disability. And the law provided that to be disabled, that definition must be broadly construed. It expands the definition of major life activity and makes it easier to prove a substantial limitation, and eliminated language like you had to prove that you severely or significantly restricted in a major life activity. So it's generally very easy to prove that you have an individual with a disability. You don't have to consider mitigating measures or things like that. However, I did want to point out that on slide 5, next slide please, I just give you the fundamental definition, which is an individual with a disability is someone with an impairment of a major life activity that is substantial or has a history of a disability or is regarded as disabled. Now, for those of you who have been looking at EEOC law, you will note that it is very rare to find any case, if at all, defining whether somebody is an individual with a disability. Normally, what they do now is talk about whether you are a qualified individual with a disability. I did want to point out, at least, however, there is a recent case called IDELL, IDELL versus Vilselak Department of Agriculture. So this person had surgery on her left foot and took 2 weeks of sick leave for surgery, but requested additional time to work at home to recover, and the recovery time was approximately 6 weeks. In this case, the EEOC did find that given the temporary nature of the medical condition and given the fact that it was not, and there was insufficient evidence to show how it affected really her major life activities beyond that short period of time of 6 weeks, that she was not an individual with a disability. So they essentially ruled against her. She was not an individual with a disability. Next slide, please. So what I'd like to talk about now is the definition of qualified individual with a disability. And essentially, a qualified individual with a disability is an individual with a disability who, with or without reasonable accommodation, can perform the essential functions of the position in question. And a tremendous amount of work goes into discussing and figuring out what the essential functions of a job is. So essential functions are those fundamental duties of a job, that is, the outcomes that must be achieved by someone in that position. And there's been a lot of litigation in this, particularly recently. We're going to talk about these cases in some depth. So an essential function and job performance are not exactly the same thing. And work performance typically encompasses not only how well an employee performs fundamental duties of a position, but also marginal duties, whereas essential functions are only those duties that are fundamental to the job, and we'll talk about cases that discuss that. Anyway, in order to figure out whether or not a function is essential, you refer to the criteria on the slide. The reason the positions exist, limited number of employees, highly specialized, are very often considered. So reason position exists. If somebody is a clerk typist, their inability to type is a good example of someone who cannot perform the essential functions of a typist. Limited number of employees. We'll find a number of cases where because there were a number of other employees that could perform some of the functions that the employee was unable to perform, that they were able to perform, that those functions became non-essential functions. And also if the functions are highly specialized. Note that employer's judgment is part of the overall discussion here, and so in a close case, the employee's judgment as to what is essential and what is not may very well swing the case on behalf of the agency. There are as well written job descriptions, so the judges are trained to look at the position descriptions, and so it's in your interest to essentially accurately describe what the job does in the PDs. If you have inaccurate PDs, it's a good time to try to rewrite them. Of course, I know that could be an exhausting process, but it is a factor that a judge is going to look at, say over at the EEOC, determine what is essential. Another one is the amount of on-the-job time the function consumes. So if only a small part of the job is involving that function, that could be indicative that it is not an essential function. Consequences if the function is not performed. So there could even be a minor function, but in meaning minor, not minor in its impact, but minor in the amount of time is used, but it could still be essential. So let me give you a good example of that. You have an individual who is a bus driver, and he has a requirement to be able to lift 30 pounds. Or at least 30 or 50 pounds. And the question becomes, well, why? Why does he have to be able to lift 30 to 50 pounds to be a bus driver? Because if that, and this is, a bus to elementary school. So if the bus gets into an accident, and the bus, for example, is on fire or it gets into a precarious situation, one of the duties of the bus driver would be expected to lift the student out of the bus. So the chances of having a requirement to lift a student out of the bus is minimal, meaning not minimal, but in the amount of time you'd express them to do that, it'd be very rare that that would happen. However, the consequences of not performing that function, if time was needed, is critical. So that the ability to lift in that circumstance would become an essential function. You also want to look at the terms of collective bargaining agreements. And of course, under the famous case Barnett, if there is a critical issue involving a seniority agreement, that often may trump the terms of a reassignment in deciding what the appropriate function is. And finally, experience of past and current employees. So the PD could say anything it wants, but if the testimony comes in that based on past and current employees, a certain function is done all the time, that will often carry the day. So you need to look at those issues. Next slide, please. Next slide after that, I'm sorry. So complainant versus Department of Labor, I just want to talk about a few cases in this regard. So in complainant versus Department of Labor, you have a claims examiner who requested no complex decisions and was unable to perform the essential functions of the job of adjudicating claims for occupational illness compensation. And essentially the job, it was found, required the individual to perform issue these complex decisions under severe time constraints because they had quotas in order to get these things out. So the inability of the individual because of anxiety, depression, stress, to be unable to perform the essential functions of their job as claims examiner was upheld, and the removal was accordingly upheld. You cannot essentially require a claims examiner who has to complete deadlines and excuse those deadlines. You never have to eliminate as a reasonable accommodation essential functions of a job. The next case on the slides is Carol K. versus Department of Agriculture. So in that case, again, as read on the slide, there you had a botanist who had a problem with their knee and was unable to perform certain essentials of the job involving walking over rugged and steep terrain. The inability to, that it was clear that the nature of their job required them to walk over this rugged and steep terrain, and therefore the inability to perform was unable to perform certain essential functions of the job in a forest setting. A third case, again, being upheld by management, and we're trying to get recent cases, so you'll note they're mostly 2015 and 2016 decision. Involved the case of Bernice R. versus Federal Mediation and Conciliation Service. So here, again, you had an HR specialist who suffered from physical and mental disabilities that prevented her from traveling, speaking in a classroom training voice, and dealing with work-related stress. A lot of her job involved being in the training room and dealing with stress-related issues, and she was unable to travel and was unable to engage in face-to-face interaction. So as a result of her medical condition, she was, again, another example of not a qualified individual with a disability. So those were three cases where the agency was upheld in defining what essential functions are. Now I want to talk about an interesting case called Johanna S. It's a 2016 case, and it's a case that goes against the agency. So here you had a GS-12 law enforcement officer who was conducting raids on certain marijuana grow sites and was unable to participate on the ground because of a back injury. So there was two aspects to the position. One was they had to draft a investigative plan as to how they were going to investigate potential marijuana grow sites, and then they had to institute an eradication plan, meaning they would somehow go on the site and eradicate all of the marijuana that was growing in the area. This individual, because of the back injury, was unable to go on the to walk on the terrain and do the on-the-ground raids. So what happened is the administrative judge rendered a decision finding that this was not a qualified individual with a disability because the person could not perform the essential functions of performing the full range of functions, which including on-site eradication plan implementation. When it went up to the EEOC, they reversed. They found that, number one, that there was, as part of the eradication process, a helicopter which would be used as part of the eradication to identify the sites that needed to be eradicated, and that the complainant had gone into this particular helicopter, and that was how she assisted in the eradication process. So even though she was unable to go on the ground, she was assisting and doing her job in the eradication process on the helicopter. Moreover, in that position, she had previously received a very high performance appraisal, a superior rating. And so when they wanted to take away the duties, or when she was unable to perform the duties and they wanted to remove her, as we'll talk about later, for medical inability to perform, they were unable to substantiate it because they were saying, how could you get a superior rating while you were flying in this helicopter, doing the essential functions of the job? It seems to me that the agency has, in essence, conceded by giving you this high rating that you had performed were performing the essential functions of the job, and that they also looked at the number of times you had to be on the ground, and they said it was like once a month or something of that nature. And so when they took everything together, they ruled on behalf of the employee, saying that that was not a that being on the ground during these raids was not an essential function. So one of the lessons learned in this arena is to focus on the fact that there are real consequences for how the agency has previously treated employees with disabilities. And the very fact that they rated that individual as superior in the past turned out to undermine the agency's decision to assert that being on the ground was in doing these raids, an essential function. The other thing that was very interesting about the Johanna S. case is when the supervisor got on the witness stand and he testified as to why he lowered the individual's performance appraisal. He basically said that, well, she couldn't perform the full array of those job duties. That's why and it was a new supervisor, that's why I lowered her rating from superior to fully successful. Well, an employee can only perform the job duties that you give them. And so the finding of the court was this was direct evidence. So somebody, for example, and they cite to a series of cases that had similar disturbing outcomes. So, for example, if somebody was on approved leave because of their reasonable accommodation they received for extended period of time, and then the employee reduced their performance appraisal because they weren't here as much as everyone else, rather than focusing on specifically the job duties, that was kind of also discussed as one of the cases where that was direct evidence of discrimination. So the key component is whatever the work that you get, you have to evaluate that person appropriately as to how they perform that compared to their standards. Now, another case that has caused a significant amount of stir, and we need to really talk about this one, is the Alvera case. Many of you probably know about this. And again, we're continuing to talk about essential functions. So for those of you who don't know what a special panel is, because that's a special panel decision, you have a case that arises oftentimes before the Merit Systems Protection Board, and then the matter is appealed before the EEOC, and sometimes the EEOC and the MSPB disagree as to the outcome of a case. And when that occurs, you have a special panel that is designed to address the decision and once again and issue a final decision, and that special panel will usually defer to the EEOC if it is a fundamentally EEO/discrimination issue, and they will defer to the MSPB if it's a fundamentally civil service law position. Well, in this case, you had an individual who was a Customs and Border Patrol agent, and he suffered from sleep apnea. As a result, he was not able to perform the graveyard shift. And of course, nobody wants to work the graveyard shift. And so the agency determined that this person was not a qualified individual with a disability because they could not perform the graveyard shift. You have to be available to work any shift at any time, and otherwise it would be unfair to the other coworkers who don't want to work the graveyard shift as well. So essentially, the MSPB upheld the removal, and the individual appealed to the EEOC, and Alvera, the EEOC reversed the MSPB or disagreed with the MSPB and said, no, attendance is not an essential function. Essential functions are the actual things that you accomplish on the job. Attendance is not a essential function, and so they ruled on behalf of the EEOC ruled and restored the employee to his job. Well, the MSPB disagreed with that, and the matter went up to the special panel, which happens extremely rarely. I don't know if there's been even a dozen cases before the special panel since 1979. But whatever it is, the special panel upheld the EEOC. So here was the critical component here, was that with regard to the ability to perform the graveyard shift, they agreed with the EEOC, saying attendance is not necessarily an essential function, that what you would have to do in this circumstance is examine if the reasonable accommodation at issue was altering because of the sleep apnea, the schedule of the individual. It would be to examine whether this would cause an undue hardship on the agency. And they basically said, the special panel and the EEOC, there was not an undue hardship. Why? Because there was like 700 Customs and Border Patrol agents in the area, and that could be performing this shift, and there was not a reason why, if one of them could not perform the duties during the graveyard shift, that it would cause undue hardship for the agency. It was not, I think it's pretty clear to me reading the case, is if there were 3 or 4 Customs or Border Patrol agents, and one of them could no longer do the graveyard shift, that probably would have been an undue hardship, because it would have presented an undue pressure on the agency and the employees to carry the burden of that shift. However, that was not the facts of the case. And so the employee won and got his job back. The next case is on the same slide as complainant versus Carter. Again, a pretty typical case, just that a store worker was unable to perform the essential functions because of an inability to break down daily deliveries or lift boxes over 30 pounds because of a back ailment. So the one thing that, next slide please, I just wanted to briefly discuss, which I discussed in my last presentation, but I really just can't resist raising it again, is that when we talk about disability law, oftentimes there are myths and fears associated with a medical condition, and it is critically important for a agency, HR specialist, or EEO specialist to carefully examine the medical evidence to figure out what an individual can and cannot do. Oftentimes, whether we want to or not, we have biases, stereotypes associated with a medical condition. This is exactly why our line indicated we should avoid. We have to make sound judgments based on, sound medical evidence. So again, just in the Keith case versus the County of Oakland, there you had a deaf lifeguard, and in a kind of a Six Flags type swimming pool, and the person was not hired because they felt that in order for that lifeguard to be do their job and keep the children and other folks safe, they had to be able to hear someone screaming, raising their hands, and calling out for help. Well, the the private sector employer did not take into account a number of things. There was evidence that shows that in a pool situation there is screaming and noise is so loud that usually you can't hear someone calling for help. They also didn't take into account that very often the essential function is to be able to see somebody who is drowning rather than to hear it for the reasons I just described. And in fact, there was testimony from that Gallaudet University has itself a school for lifeguards, and that there were other accommodations if somebody had to question them or whatever it is, to blow a whistle, to get help from others. And the point is, I raised this case only because when I was reading it, I myself was thinking at one point that, oh, this person can't perform the essential functions of the job of a lifeguard safely, but there was medical evidence in the record to show that they could, potentially, and so the case was remanded for further trial. So I just raised that with you to open up your eyes to, the flexibility associated with medical condition. So the other thing I want to raise is, the very definition, next slide please, is definition of reasonable accommodation is set forth at, that's by the way, 29 CFR 1630.20. You're required to provide reasonable accommodation to a qualified individual with a disability with a substantially limited impairment or record of such an impairment. However, a covered entity is not required to provide an accommodation of an individual who meets the definition of a disability solely under the regarded as prong. So reasonable accommodation only applies to the first prong, which is whether a qualified individual with a reasonable can perform the essential functions of a job with or without reasonable accommodation. It does not apply to the regarded as prong. So one of the things that, go to the next slide, I want to just discuss too is reasonable accommodation will take many different forms. So it will involve technology, it will involve changes in how you do business, where you work is an area, and we'll discuss all those different avenues in a moment for considering a request for reasonable accommodation. However, I want to just remind everybody that the central case involving the definition of reasonable accommodation is a case called U.S. Airways versus Barnett. It's a Supreme Court decision that's set forth in the decisions. And again, it shows that the complainant under the Supreme Court not involved like an injured person with an injured back was a cargo handler and required to be reassigned, and because they couldn't perform their cargo handler duties, and the Supreme Court ruled that a directed reassignment when there was a seniority provision in a collective bargaining agreement was not a basis to grant a reasonable accommodation, that was not reasonable under the circumstances. but this case is most important for discussing the general framework of addressing requests for reasonable accommodation. So it explains, in one of the first cases, Dwight B., the complainant has the initial responsibility for showing that a suggested accommodation is reasonable. That is, by showing it's reasonable, that there's an initial plausibility threshold that the complainant must meet. Once the complainant shows that the requested accommodation is plausible, the burden then shifts to the agency to show that whether the accommodation, even if plausible, would nonetheless impose an undue hardship. A second case, the Hertha case on the same page, the word accommodation conveys the need for effectiveness. An ineffective modification or adjustment will not accommodate a disabled individual's limitations. In the context of job performance, this means a reasonable accommodation enables the individual to perform the essential functions of the position. And again, any accommodations must be reasonable. The agency never has to make decisions that eliminate essential functions. The agency can always choose between effective accommodations and can always choose between reasonable accommodations. Other language on the next slide is additional questions such as engaging a modification or adjustment is reasonable if it seems reasonable on its face, ordinarily in the run of cases, feasible or plausible. If we could go to the next slide, please. So, EEOC's guidance on reasonable accommodation clarifies the nature of accommodations are making existing facilities readily accessible, job restructuring, part-time or modified work schedules, reassignment to a vacant position, equipment, appropriate adjustment to modifications, training materials, qualified readers or interpreters, and others. Next slide, please. Again, this slide emphasizes an employer never has to reallocate essential functions, and the employee is entitled to reasonable effective accommodation, not the accommodation of choice. And you consider the employee's request, but the agency, again, can choose from two effective accommodations. What I'm going to do is talk a little bit now about the interactive dialogue, and then go through specific examples of reasonable accommodation and specific questions. So what you will find when you look at reasonable accommodation disability law cases, you will find that essentially it is critical that the agency engage with the employee in the interactive process. That means, to utilize Joan Rivers' phrase, can we talk? And it means that the parties should work out the issues and problems that they're trying to address in the workplace. If an agency does not participate in the interactive process, then the impact of that is that the agency could still prevail if a reasonable accommodation was not necessarily required, and if they couldn't articulate a reasonable one. But if there are circumstances where there is a reasonable accommodation that might be available, and the employee was unable to did not engage in the interactive process, the agency may very well be held liable. So I wanted to raise those issues so that you must make a reasonable effort to try to talk to the employee. And I might add, if the employee does not cooperate in the reasonable accommodation process, that is a basis to deny a reasonable accommodation request. The thing I wanted to emphasize is my experience is that supervisors tend to be well-meaning, but sometimes what they don't understand is that they they feel like they have to follow the rules no matter what the schedule is, telework rules, leave rules, and it applies to everybody, and they don't understand that the a request for reasonable accommodation is a request to alter those rules for legal reasons and where they can be effective and you could otherwise perform the essential functions of the job or not otherwise cause an undue hardship. So again, what I always tell supervisors when I talk to them is don't be the waitress. If you have that reflexive reaction that says no, step back and think about it. Talk to your HR specialist, talk to your attorney on that, and make sure before you say no, it's based upon sound medical judgment, and that and that it's legally justified. So with that, I'd like to turn to the next slide, which is examples of reasonable accommodation. So here we're going to get into a little bit more of examples, and of course one of them is technology, and all sorts of issues, and technology make accommodations certainly more possible. And it's really one of the remarkable things about disability law is the interrelationship between technological advances and reasonable accommodation. But let's just talk a little bit about telework, because I know many of you have this question. So telework is part of the analysis that says reasonable accommodation applies not only in performing the essential functions of your job, but also in where you perform those essential functions. And very often there is a reflexive reaction by some managers, not to grant a telework assignment. So here's one, complainant versus Jay Johnson on your screen, where telework was properly denied. Complainant's position required her to spend 80% of her time working with special needs families who come directly to the office to meet with complainant. Again, the individual, because of their medical condition, was unable to drive an extended period of time, and so what she wanted, and she was a family resource specialist at GS11, what she wanted to do was work in one Sacramento office and then work in another office, and also to work an extended amount of time at home. Essentially, the agency denied her request because they said working with special needs families require you to be present, requires you to come directly to the office to meet the people that you are serving. If the complainant teleworked from home, she would be unable to help individuals who came into the office. And so they also remarked the staff is very small. There's regular out-of-office schedules for complainant and others, and just having her be able to work remotely just didn't cut it. And so the request was denied. So it wasn't just working at home. In that particular case, she said, well, what if I worked predominantly out of an office that was closer to where I live? The problem is that the people she was expected to serve was in an office far away, so the employee was, in essence, expecting her clients to drive all this way to accommodate her, and that was, and these are public, are citizens. So the decision was that that was not a essential function of that she could not perform the essential functions of her job with a reasonable accommodation of telework. So another case is similar to one I had mentioned earlier, a case called Laverne v. Castro. And this case involved a financial analyst with disability affecting his spine, and he identified 100% telework where a male could be scanned and not excessive, meetings and training via telework or video conference, and could occasionally travel. The person's spine just made it very, very difficult to commute. They can only come in occasionally. The fact that, once again, the fact that the complainant received a fully successful annual evaluation while telecommuting 100% of the time greatly undermines the agency's contention that his inability to report to the Minneapolis office creates an undue burden on the agency. So what they did was they looked at all of the individual aspects of this financial analyst job, and they determined that case by case, fact by fact, there just was insufficient evidence to suggest that the person could not perform those jobs, those aspects of her job at home. And one of the things was there was a lot of talk by the employee about the supervisor. You know, you have to be in the office. It develops morale. It develops camaraderie. But that was insufficient to justify not permitting the person to do 100% telework. Do we have any questions at this point? Okay. So the next question is, next case is complainant versus Brennan. And that, again, is a case involving somebody who had epilepsy. And there were periods where the employee could not care for himself. And so he returned to work. And in that case, he returned to work, and he was absent essentially without leave for a few days. But the medical evidence showed that because of the person's epilepsy, the individual was unable to call the supervisor. And so the argument on behalf of the employee was, I realized that I was absent without leave, but I called in the very next day, and it only happened like once in a blue moon, and you are prohibiting me from I shouldn't thereby be adversely affected, and I shouldn't get disciplined. And the EEOC agreed with that individual because they could show that they were unable to perform the essential. He was unable to call in because of his medical condition, and that's how they proved that. And then, so there's a few more cases like that. Next slide, please. Another case is job restructuring. Another case, meaning another typical accommodation, is job restructuring. And here, normally the reallocation or redistribution of non-essential marginal functions is what job restructuring involves. It provides that an employer can reasonably accommodate an employee with a disability-related injury by restructuring the position. Here, the agency couldn't accommodate the individual's needs because of phobias by restructuring a managerial or supervisory position by reallocating to him marginal administrative tasks. Clearly, as a manager, his job was to manage, eliminating management and supervising of employees of a manager on its face is an essential function. Is clearly we find the complainant was not qualified individual. That was not effective job restructuring. Likewise, in Lowell H., 2016 decision, the agency was not required to lower production standards or reallocate essential functions as a reasonable accommodation for a veterans claims examiner who could not meet the 240 cases per month quota because of arthritis. So that's, again, an example where job restructuring was not effective. And there's also an accommodation of altering the way things are typically done. For example, altering written instructions instead of giving oral instructions, giving written instructions, for example, for those who might have concentration issues, and written instructions might be more helpful. Next slide. So there's a lot of case law involving problems with leave and issues associated with leave. So two cases that I'll talk about, and then a third one, the Ava Underwood case, which is on page 7 of your outline. Number one is an employee is not entitled to indefinite leave. So employee was not entitled to provide recovery time of 2 years as a reasonable accommodation with no expected date of return. Doesn't have to provide paid leave beyond that, which is provided to similarly situated employees. So again, if an individual is on paid leave, if individual is on indefinite leave, there's no chance of that person, or doesn't sound like that person is going to come back anytime soon, that is a basis to deny that leave request. Similarly, and this is where it gets interesting with regard to unscheduled leave, a request for unscheduled leave 4 to 6 times a month would have caused an undue hardship for a mail handler with vision and lung impairments, given they already had been out for 400 hours of leave. So this unscheduled leave, being out 4 to 6 times a month, the agency could not predict when he was going to come to work, and found that that person was not a qualified individual with a disability. On the flip side, there is an interesting case called Ava Underwood. It's on page 7 of your outline of cases. So this complainant suffered from PTSD and bipolar. And the person engaged in basically required some degree of unscheduled leave. And there was an abeyance agreement, and the abeyance agreement, because of leave issues, essentially said, if you are on unscheduled leave, if you come in a certain number of times, you must bring in a doctor's note every time you come back to the workplace. And essentially, when the doctor saw this requirement, there was a couple of things. Number one is the doctor said, this is a ridiculous amount of leave, and the ridiculous amount, of requested medical evidence, and I'm not going to provide a doctor's note each and every time you ask me to provide one. And then, in addition, there was another factor. Although the abeyance agreement required a medical, a letter from the doctor after each time they were absent, it was determined that perhaps it could be workable, meaning the employee testified, perhaps if I just was allowed 6 times a year to come to work late, if I was unable, meaning not late, but if I called in, I was, because of my PTSD, I wasn't able to get in. I just couldn't get out of bed, which is a part of the person's problem. I didn't have to worry about bringing you the medical if it was just 6 times a year. And the EEOC agreed and said that was a reasonable accommodation given the person's medical condition. And again, unscheduled doesn't mean you don't, it means that you wake up and because of your medical limitations, you just feel like you can't come in that day. They're basically saying you don't have to bring in medical for 6 times. And one of the key components of that case, which goes back to an area of interactive dialogue, is that the agency never sat down with the employee after the abeyance agreement to discuss the unscheduled leave issue. Didn't sit down with the employee and say, I don't make that much money, my doctor is being difficult, he doesn't want to give me a medical note every time I'm out for a day or whatever it is. In fact, the doctor called the request for medical, quote unquote, absurd and too detailed and all that. And one of the things that the EEOC got the agency on was, you know what? When there's an interactive dialogue issue, you don't address the agency can prevail, again, as I stated earlier, where there isn't a potential reasonable accommodation that could assist the employee. But here there was one. 6 times a year, don't have to bring in a medical note, that might have worked. And by failing to engage in the interactive dialogue, you have engaged in discrimination in the form of reasonable accommodation discrimination. So that was an interesting case. That's the Ava Underwood case on page 7 of your outline of cases. Now, another area that I am I am talking about today is the issue dealing with interpreters. So there's a series of cases really that have been developed, over the years, but recently emphasized that there are certain circumstances where you're expected to provide an interpreter and certain circumstances where you're not. And so let me just first start by talking about complainant versus U.S. Postal Service. There, it clarifies reasonable accommodation at a minimum, requires providing an interpreter for safety talks, discussions on work procedures, policies or assignment, and for every disciplinary action so that the employee can understand what is occurring at every crucial time in his or her employment career, whether or not he or she asks for an interpreter. So that's generally the rule. Safety talks, discussions on work procedures, policies or assignment, and for disciplinary action. Note, just generally doing your work every day. There's nothing in there that says that you have to have an interpreter, for example, full-time, and that is addressed in more detail later. So in a next case, Steele versus Pension Benefit Guarantee Corporation, a deaf employee was entitled to effective accommodation, but not a perfect accommodation. So they were entitled to qualified interpreters, and the agency reasonably accommodated the employee by providing a pool of preferred interpreters, even if they weren't available all of the time. So, the agency, if the agency wants to try to get the employee the interpreter that they want, that's fine, but they're not required to do that by providing a pool of preferred interpreters that had satisfied their reasonable accommodation responsibilities. Remember, an accommodation must be effective, and it doesn't have to be the perfect accommodation, and so those are some examples there. Agency in the next case, Lupi M. The agency provided reasonable accommodation to a deaf distribution supervisor and gave him the ability to schedule an on-site interpreter. So it's okay for an employee to have the on-site interpreter be requested by the employee. But the employee claimed it was difficult to communicate with others because without a full-time interpreter, impromptu meetings were difficult, and some employees did not want to communicate in writing because of limited English literacy. The employee request for a full-time interpreter was denied on the grounds that the employee was successful at the essential function of the job without the accommodations, and generally that's not within the normal, normally the kind of accommodation that's provided in the run of cases a la Barnett. The employee has not shown that the existing accommodations were effective, and one of the things they looked at was, look, the person had an effective job performance rating, so that was also something that underscored the reason why the person didn't need a full-time interpreter. Now, this next case is one that went for the employee. The agency did not make a good faith effort to accommodate the deaf mail handler. The employee was unable to participate in a last-minute meeting, and the agency promises it would hold a repeat meeting with an interpreter that were not fulfilled. And when the scheduled interpreter did not show up. They found the agency's tepid promises to the employer were mere lip service, which did not show good faith. In other words, the interpreter was expected to show up for a meeting, was not able to show up for the meeting. The agency promised it would hold a repeat meeting. They didn't get never followed up with the repeat meeting. So the EEOC, in my view, reading this case, understands, particularly with interpreters, that things happen, and sometimes good faith results in a breakdown. Maybe the interpreter can't come in, or whatever the case might be, or there could be other barriers that occur. But the point is, if you hold the meeting and then you promise you're going to hold a repeat meeting, which sounds like it would have been an appropriate response, you better follow up on your promise. The key component here was the sense that the agency was just giving lip service, was not really trying to help the deaf employee receive the interpreting services for that meeting, and therefore the agency was found to have discriminated in not providing an effective accommodation and providing a timely interpreter. So these are a number of other issues, but I wanted to also next go on to another area that I have found in my own world is, thank you, next slide, that's a good slide, which is an area of great confusion to HR specialists and EEO specialists alike, as well as lawyers, of course, which is the accommodation related to commuting. So here's the thing. It's a fundamental concept. The EEOC agreed to this, in essence, in a recent case called Gerald versus McDonald, that the agency has no responsibility to provide transportation to an employee for his commute. So there was a lot of discussions about appropriations law, and it's the employee's responsibility to get to and from work, however it means they do it, and the agency does not have to pay from getting to and from work. The agency was not obligated to provide a driver. There was a shuttle that went from one facility to another, but it was being used by the employee essentially to get to work, and that was a problem. And they also pointed out that the use of the shuttle from one site to the other where the employee was supposed to start would not have been affected because its schedule was not conducive to the employee's schedule. And then the agency, importantly, made reasonable efforts to accommodate the employee by offering part-time work and providing carpool options. So it's extremely important there that the agency looks like it's trying to work with the employee and helping them get to the job. And so they ultimately ruled that excusing the complainant for serving patients in Muskogee Medical Facility, which was far away, was not reasonable, would cause an undue hardship in denial of a service to patients closer to their home, similar to another case, and always having to drive further away than where they normally would be, which is the Tulsa facility. The flip side of this case is in Castro versus Department of Housing and Urban Development. So what I want to say here, so you understand, is it may be that you do not have to pay for and provide transportation to an employee for his commute. But the EEOC has clearly recognized that you are required to take reasonable accommodations in the form of allowing the person maybe to be reassigned to a different location so that you will be closer to home, or to use telework. So if you're too far away and it's causing a problem with your back impairment or whatever your medical condition might be, that could be a appropriate, reasonable accommodation. So yes, you don't have to provide the employee with paying for them to get to work, but you do have to allow them accommodations which will make it easier for them to get to work, either by moving them closer to work through a reassignment or by allowing them to work at home. And in Castro, you had a complainant, a financial analyst, with a very painful spine condition that was exacerbated by this 10-hour commute, requesting a reasonable accommodation in the form of full-time telework. And the EEOC held that the request for a shorter commuting time triggers the agency's responsibility to consider requests for reasonable accommodation. And the individual's job was not such that he could not perform the essential functions of his job accordingly. So, turning the slide now to reassignment. So, the area of reassignment is important. A qualified individual with a disability is not just whether you can perform the essential functions of the position you occupy, but whether you can also perform the essential functions of a position you desire and are vacant and funded and in which you are qualified. Reassignment is always an accommodation of last choice. If the person is able to perform the essential functions of their job with an accommodation, that will normally be the accommodation approved unless the parties agree otherwise. In the case of, so the key component here is you don't have to create a job in a reassignment case. You don't have to, there has to be a vacant funded position, and you have to consider accommodations first within the person's job. Another thing that can be confusing for those of you who are not veterans of this area is reassignment is not limited to the commuting area. It is nationwide within the organization. So it is very critical that you consider that you work with your HR specialist, your merit staffing specialist, for example, to figure out whether there is a vacant funded position, where it is, and then whether the person is qualified. Those decisions are best made by the staffing specialist who has expertise in the area. Again, when you're dealing with reassignment, it's a good way to go through the interactive dialogue to talk it through with the employee. But in Thompson versus Department of Air Force, the individual was a contract negotiator and suffered from depression and panic anxiety disorder. And essentially, while the complainant indicated he would have been receptive to a reassignment when he was having difficulties performing his current job, he did not identify a vacant funded position for which he could have performed the essential functions with or without reasonable accommodation. And that is the key, and also when the agency did search for a job and couldn't find one. The key component is if an employee is alleging that they should have been reassigned, and the agency doesn't do it, it is the employee's burden to have identified that there was in fact an essential function, a vacant funded position. And there are several ways to do that, but essentially that's the burden on the employee. The next point, though, that I wanted to focus on is also in Gonzalez, there was a search, but the only position that was available was a promotion. And so that was found to be not a reasonable accommodation, and that's an MSPB case, 2010. Now, if you recall, I started out this presentation with the Crown of Thorns case. That's the Matilda versus Carolyn Colvin. This was initially discussed in the slide 2. But I wanted to talk about it again. But in this case with regard to reassignment. So first, let me start with Belton versus Shinseki, which is the case lower on the page. And what's fascinating about this case is very often when you have an interaction between employee and supervisor, it is like a war of, sometimes it can be a battleground. The supervisor doesn't get along with the employee doesn't get along with the supervisor. I deal with employment law, but I can tell you sometimes it feels like divorce law. So essentially in Belton, they emphasized, and this is clearly as well in EEOC enforcement guidance, that you do not have to consider that a request to be reassigned from one supervisor to another is normally not considered a request for a reasonable accommodation. You just don't have to do it. So in other words, if there are two positions, say there are both HR specialists, and they both require the exact same jobs, exact same duties, it's just one has a supervisor that you prefer, or that the other one is more difficult to the employee, and the employee wants a reassignment just to get away from that supervisor. The EEOC's enforcement guidance, October 2002 guidance, was at the back, and I'll refer it to you later, as well as numerous cases say that is not considered a request for reasonable accommodation, and you do not have to do that. However, in this 2017 decision, an interesting crack has developed, which is that complainant alleged harassment based on disability. Remember the Crown of Thorns issue and alleged that he was not entitled to reassignment to a different supervisor. And in that case, they agreed. They said the person had gotten, once again, a fully successful performance appraisal. There was no reason to believe that he couldn't perform effectively in his current job, and so reassigning him to a different supervisor was not a reasonable accommodation. And it reinstituted the advice that movement of a supervisor from one position to another position, which was not any different, just to get away from a supervisor, is not a request for reasonable accommodation. But here's what they then added. They clarified, however, that notwithstanding the foregoing guidance, which is question 3 of the enforcement guidance and other case law, agencies nonetheless are required to undertake an individualized assessment as part of the reasonable accommodation process, even when the accommodation requested amounts to a request for a different supervisor. Meaning, the agency is wise when an employee is requesting the same position but just with a different supervisor to still talk to the employee, engage in an individualized assessment, because somewhere down the line there may be a decision raised where such a reassignment is considered a request for reasonable accommodation. So as long as you've considered the employee's interest but then said, no, we're not going to do that, if that's where you go, if it's reasoned and understandable, you're going to be okay. So you should definitely read the Matilda versus Carolyn Colvin case. That is not in the summary document I gave you because it just recently came out. But I recommend that you have your attorneys, if not yourselves, review that decision. There's a lot on slide 24 involving timely response to accommodation request. And remember, delays of 4, 6, 9 months have all been found to violate the law. You need to be very careful, and these are the factors in Shealy: the reason for the delay, the length of the delay, how much an individual with disability contribute to the delay, what the employer was doing during the delay, and whether the required accommodation was simple or complex. So what I wanted to point out is on page 12 of this PowerPoint, there is a case that is referred to called Hertha, H-E-R-T-H-A, and that is an interesting case because it involved a delay that was upheld as non-discriminatory by the EEOC. In that particular case, the individual had a wrist injury. There was all sorts of technology that was provided to voice-activated software and the like that was provided to assist the employee to perform the essential functions of the job. And while they were trying to get all these different types of software and technologies, they reduced his workload. But it took a really, really long time. Here is what saved the agency. Number one is many of the delays were outside their control. Number two, they really bent over backwards to keep the employee informed. And also, of course, there were issues where the employee added to the delay by not necessarily fully cooperating. So just a blanket delay, you still have defenses, but the best thing to do is always show that you're interested, show that you're caring, you're doing your best to grant those accommodations. If you can do that, even if there's a delay, you're going to be probably, hopefully you'll be okay. Again, sometimes if you request medical documentation from the employee that is fair and reasonable and they don't provide it, or it takes a long time to do it, that is also an exception recognized by the EEOC as a basis for a delay. The next slide is another important concept. Next slide, on undue hardship. So even if an accommodation is reasonable, it could cause an undue hardship, meaning it could create unreasonable cost or difficulty providing a specific accommodation. So just a few cases on slide 26. Request for unscheduled leave 4 to 6 months times a month, where the person has already been out 400 hours, was considered to be an undue hardship on the agency. And then, but here's a case that went the other way, where the agency failed to show undue hardship. You had a sales store checker who wanted a 10-minute break every hour to accommodate her shoulder pain and carpal tunnel. They couldn't show how that would be disruptive or to the agency. For those of you who don't know, cost is virtually never a basis for undue hardship defense. And if it comes down to money, my recommendation is find it. By the way, a best practice is to have a centralized reasonable accommodation fund where you can get it as opposed to specific office funds. And again, another case that was similar to Avera is complainant versus Department of Homeland Security. Determination of undue hardship is based upon the nature and cost of the accommodation, the overall financial resources of the facility, the size, number of employees. We talked a little bit about that. Types of operations, including the structure and functions of the workplace, geographic separateness, the impact of the accommodation on the operation of the facility. And again, it was not an undue hardship to have a Custom and Border officers monitor at all time 4 bridges connecting the United States and Mexico. The swapping of shifts, was not a basis to find an undue hardship, given that there were so many people. The burden on the individual was not a basis to find discrimination, and the agency, the agency was found to have discriminated because it wouldn't have caused an undue hardship to give the person the shift they requested. Okay, now what I'd like to do is turn our attention to obtaining medical documentation and assessing the probative weight of documentation. So what I just want to tell you is one of the areas as a lawyer that I always wrestle with is how to evaluate medical documentation. So again, an agency is entitled to request medical when they need it to assess whether the employee is suffering from a disability, or if they're a qualified individual with a disability, or to assess potential reasonable accommodations. Where the medical condition is obvious, you don't get that. Questions, if you request medical and it's a reasonable request and the employee doesn't provide it, question 6 of the October 2002 guidance says you can deny the request. If it is obvious and you request it, that could be a problem and could be evidence of discrimination. So, so they requested, there was some medical evidence involving an employee who had a back injury, and he was returning from workers' comp, and it said no inmate contact was allowed. And this person worked in a gun tower at a prison. And so what was happening is when the prisoners were released in an area where the employee was, he had to come off that tour for fear of inmate contact. Essentially, the agency reconsidered the request because they started to think, well, an essential function of the job might be to involve dealing with inmates, and might require still climbing and stairs and dealing with inmates when they are, in fact, in the gun tower. And so they requested additional medical to make sure that that was the case, and that was found to be appropriate. Now, a case where requesting medical evidence was found to be not appropriate was there was a temporary accommodation involving a handicapped parking spot. The individual had difficulty walking. The person produced medical evidence that they had a permanent condition and that they needed a permanent parking spot, and then despite having that evidence, they continued to request medical evidence. That's the Joanne Hurd case. Now, talking about the probative nature of medical, I just want to talk about a few interesting cases. So, in Brown versus Department of Interior, they talk about the factors to consider when determining whether or not what's more probative, the employee's doctor or the agency's doctor. So, you look at the medical evidence. Is the medical evidence that the employee gave you a reasoned explanation, or is it conclusory? What are the qualifications of the expert? What is the extent and familiarity with treatment of the employee? What is the knowledge of the employee's job PD? So very often you'll get a document from an employee's doctor giving you information about the employee's condition and ability to do the job, but there's no evidence that they know what the employee's done other than what the employee says. That could be a problem for the employee. The EEOC and the MSPB look at that factor. In this particular case, in Brown versus Department of Army, again an MSPB case, a GS-12 criminal investigator with a history of back injury subjected to an annual fitness for duty did not meet certain medical standards for her position, couldn't engage in medical exertion without warning, pursue perpetrators on foot. The more probative weight was given to the agency doctor who gave a fitness for duty over the employee's doctor, because the agency doctor considered actual duties in the PD, where the employee's doctor really relied on the employee's characterization. Another case, an EEOC decision recently upheld a decision to remove a special agent, a Fish and Wildlife Service agent, because of medical inability, again, due to a back impairment. They found that the appellant's treating physicians did not base their medical opinions on the appellant's position description, again, but on their own job descriptions. So that's another example. Next slide, please. And there is another two examples. A staff assistant suffered from migraines and Chiari-S and allergies and acid reflux. The doctor's notes did not clear, it just simply said, because of these different medical conditions, she should allow to be come in late. But they did not clearly communicate that she needed to come in after 9:30, and she did not clearly state that could not otherwise be able to deal with the agency's already flexible schedule. So there was nothing in the medical that required the employee just to come in whenever they wanted and come in late. And of course, by the way, coming in whenever you wanted would probably not be a reasonable accommodation anyway, and would otherwise probably cause an undue hardship, since the predictability of the employee's attendance would be called in question. Another example is Michelle G., another EEO decisions. Employees request too open-ended and vague. Complainant requested, again, a flexible work schedule, ADD. These are 2016 cases, because she had difficulty getting ready in the morning and arriving at work on time. Although it may be a reasonable accommodation to modify a schedule, it was too open-ended and vague. There was requests like she had requested leeway with time. She may have difficulty making it at all. There was not enough detail in the medical to give it much probative weight. And again, next slide, please. Some additional slides in this area is in the area of Wren versus Department of Army. Conclusory and unspecific medical evidence limits its probative value. And so if they don't explain, and there's evidence in the doctor's opinion that's contradicted by other parts of the opinion, it's not going to be very probative, and that could be not conclusory, not supported. Conclusory medical opinion: no mobility assistance scooter at a time. You had a a court reporter who had difficulty because of a knee impairment getting into a particular courtroom in the DOD facility or the Army facility, and they just said, no mobility assistance scooter at this time. Well, that's fine, but they gave no explanation because the employee's doctor said if the person has difficulty getting into the courtroom, just give him a scooter. And the employee probably just wrote the thing himself, and the doctor just signed it. So that was a problem. And the employee lost that case. The agency won. Here's a case, though, an MSPB case where an employee said that in frustration to a doctor, the employee says he wanted to kick another officer's ass. And 3 months, later, he made sort of another comment like that. Based on those comments, the agency doctor said this guy was a danger, and they basically said there was in essence a direct threat, which we'll talk about later, and should be removed. The employee brought in 7 doctors, which contradicted the agency doctor, and made it clear that he was not in danger of gun carrying in her position, and that there was not a substantial probability of harm. So the cases go different ways. Another very interesting case is the next case, which is Clemens versus Department of Army, again on that same page at the bottom. Statements made by appellant's doctors were quote-unquote terse and unspecific regarding the accommodation. The person who suffered from a stroke said perhaps text-to-voice software could be helpful, perhaps. So are they saying he should have text-to-voice? Are they saying it would help? That was considered not even a request or a medical opinion worthy of anything, and so the MSPB appropriately discounted that. Can we go to the next slide, please? Fitness for duty. Unlike many of the private sector, we have to wrestle in the federal sector with 5 CFR 339 when it comes to fitness for duty. I just want to remind you that that in a situation like that, you must have job standards in order to order someone for a fitness for duty. Ordering someone otherwise would violate the law. Another basis by which you can order a fitness for duty if you don't have job standards is under the Family Medical Leave Act if the agency is offering a second medical opinion at agency expense, where the medical evidence to support the FEMLA request is insufficient. And that's Sullivan versus U.S. Postal Service. However, I wanted to raise another case that is not on your slide, not in this slide. It's a case called Merrill O. It's on page 18 of the slides, and essentially Merrill O versus Department of Veterans Affairs, reasonable belief that an employee was unable to perform a job or a direct threat was a basis to send him to a fitness for duty. So here the person was suffering from various, because they were diabetic. When their sugar would go low, they would kind of slap a coworker, and they would have all these like vocal outbursts. And it was appropriate under those circumstances, where they did have medical standards, to order the person for a fitness for duty. But I just wanted to point out, when I read this case, I don't understand why they didn't just discipline the employee, which we'll get to in a few minutes. Confidentiality. We've got a lot going on here. So now we're on to confidentiality. So here's the thing that everyone needs to know. It's very, very important to understand that if somebody improperly handles medical records and shares them with somebody who does not have a need to know, they have violated the ADA confidentiality requirements, and they will receive some modicum of compensatory damages, based on what I've seen, usually about $3,000. And that is the case even if the employee is not an individual with a disability. So if you bring in a doctor's note saying that you suffer from mild depression, and we would say mild depression is not a disability, but your supervisor leaves that on the break table, etc., that is a basis to find a violation of the ADA. So it's critically important to store records. The key case is Mayo versus Department of Justice, Federal Bureau of Prisons, and I believe that is the one where they put the medical in the OPF where it didn't belong, and any HR specialist could see it. And the newest case on this one really underscores how important it is to take care of medical evidence. The case is called Buster D. versus Department of Agriculture, and regarding a disciplinary action case that really didn't have anything to do with reasonable accommodation or anything to do with medical issues. Somehow one of the exhibits labeled A to triple Z was the HR specialist gave to the union a letter which identified the complainant's medical diagnosis as attention deficit order. That was a per se violation. The union rep had no reason to have that information, and it is critical to avoid that. Now I want to talk next slide, on slide 32, on performance and conduct. Could we play the little clip, please?
I want you to get up now. I want all of you to get up out of your chairs. I want you to get up right now and go to the window, open it, and stick your head out and yell, "I'm as mad as hell, and I'm not going to take this anymore!"
Okay, so why am I playing that clip? Because of those HR specialists, when you go to that supervisor, very oftentimes they are as mad as hell and they're not going to take it anymore, meaning they've tried to work with this employee, whether they have an reasonable disability or not. Very often, we know this scenario, the manager doesn't want to deal with the issues, and they kind of avoid the problem until finally they want to handle it. And that creates all sorts of problems with us in normal employee relations space, but it creates additional problems in disability law space, and that's what we're going to talk to now. So again, complainant versus Department of Army. Let me just first state on this slide that the concept of discipline is as follows: disabled employees are held to the same standards as non-disabled employees dealing with conduct in the workplace. That reasonable accommodation is always prospective, meaning that you're supposed to request reasonable accommodation before the misconduct occurs. That if the misconduct occurs and then you request a reasonable accommodation, you can deal with the misconduct just like you would deal with anyone else. It might play a role in the Douglas factor analysis for those of you who are employee relations specialists dealing in this area, but as far as addressing it as misconduct, you would address it as misconduct. So that concept is held in Complainant versus Department of Army. A diabetic complainant received a one-day suspension for leaving the work site without permission during an episode of low blood sugar. So there was no question that he just drove off. He was going at ridiculously high speeds, and there was absolutely no question that the cause of why he acted so erratically was because he had an episode of low blood sugar. That was not an excuse for the conduct. So it was appropriate to discipline them, even though the diabetes caused the misconduct. Another case was an employee complainant versus holder. Is you have an individual with certain psychiatric disabilities walks into the supervisor's desk and slams down, the file and says, "If I can't work on my cases, I'm not going to work on his." And so of course that's inappropriate conduct. They want to discipline the guy, and here is, and then he puts his finger into the supervisor's face. Hopefully my staff isn't getting any ideas at this point. And he starts effectively striking out as a supervisor and saying as if he was going to hit the supervisor, putting the supervisor in fear. So what was the accommodation? The accommodation is, can you cut me some slack? Recognize this treatment I'm going along is a drawn-out process. Well, cutting someone slack is not a reasonable accommodation. If somebody engages in misconduct, they should be treated like anyone else. Again, in Haley versus Postal Service, complainant did not notify the relevant responsible agency officials about his depression until after the absences had already occurred. And this is where they say reasonable accommodation is always prospective, and an employer is not required to excuse past misconduct. Now, the next thing is, it gets very confusing, however, with the area of performance. So with poor performance, you have a situation where I give you example 10 and the Pritzker case, cited on page 33 of the slides. So the concept is a person has a learning disability. Even when she begins having performance problems, she believes are disability related. Her supervisor counsels the employee still hasn't requested an accommodation, and then let's say, for example, they put her on a PIP, Performance Improvement Plan. Well, because they have not yet taken an unacceptable performance action, you need to stop and you need to consider the reasonable accommodation action. Doesn't mean you don't evaluate them appropriately based upon their performance as of that far. But before you remove someone, you have to, if you're putting them on the PIP, you have to first, maybe delay the PIP, allow them to get treatment, whatever the case might be, the accommodation, put it into place. It's treated differently. Where performance-based actions and conduct-based actions align is at the time that the unacceptable performance decision performance action has been raised. So if you propose to remove someone for unacceptable performance, at that stage, the employee raising a reasonable accommodation it should be considered like somebody had already engaged in misconduct. It's too late to deal with those issues. And that's the same concept that's held in Petitioner versus Pritzker. Slide 34, the next slide, underscores circumstances where, this is guidance from the EEOC, that there are circumstances where you do have to cancel a PIP and give the person an opportunity to improve at the PIP stage if, for example, the person needs, let's say, leave or other kinds of accommodations. We don't have that much time left, so I want to talk briefly about direct threat and just clarify the lead case, of course, is Escazabal versus Chevron, and the term, again, direct threat means a significant risk of substantial harm to the health and safety of individuals or others that cannot be eliminated or reduced by reasonable accommodation. So here's an example where there was a direct threat. Complainant clearly showed in Keisha versus U.S. Postal Service that she posed a danger to herself and others when she expressed to the customer service supervisor she had suicidal thoughts of driving her postal vehicle through an intersection into another vehicle. That is clearly evidence of a substantial harm to the health and safety of the individual or others. An example that went the other way. You had Nathan versus Holder, a special agent with applicant with monocular vision, was improperly denied employment. Did not show the agency, did not show a reasonable probability of substantial harm when the medical exam with this person with monocular vision, one eye, did not take into considered individualized assessment of the applicant, such as learned behaviors, practical experience, which would allow him to perform the position safely. So the person demonstrated they were able to do the job through their actual experience and abilities, and so in that case, just having monocular vision was not able to show a reasonable probability of substantial harm. The key phrase you see in every direct threat case is whether the agency engaged in an individualized assessment of the applicant. A reaction, a reflexive reaction to a medical condition is not going to cut it. And the next slide lays out in more detail the direct threat factors. So what I want to do is now go on to qualification standards. Again, sometimes you'll have medical standards that an employee has to meet. You have to show that those standards are job-related for the position in question and consistent with business necessity. So in a recent case, this was a case that was reversed. The agency, they had a 70-pound lifting standard for a sales associate position. The agency could not explain why they required such a standard. They couldn't explain why it was necessary to do the job, and hypothesizing about which standard might be sufficient or whatever was determined to require overturning that standard and allowing the employee to be retained on the job. It clarifies that the central question whenever you're dealing with a qualification standard is whether it is carefully tailored to measure an individual's actual ability to perform the essential functions of the job. Usually there's medical evidence to support the medical standards, there's practical evidence, etc. If you have neither, you need to alter that qualification standard. So what I would recommend is you go back to your qualification standards and carefully assess whether they are sufficient to support and job-related and consistent with business necessity. Slide 38, medical inability to perform. Just to clarify, there are two types of medical inability to perform. Those types are positions that are duties where you have medical standards and those where you don't. Where there's medical standards, you have to show, a la Slater versus Department of Homeland Security, that the disabling condition is itself disqualifying, its recurrence cannot be ruled out, and the duties of the position are such that a recurrence would pose a reasonable probability of substantial harm. If the employee works in a job like most of us without medical standards, the test is whether there's a nexus between the employee's medical condition and observed deficiencies in the workplace. And you can show a high probability, given the nature of the work involved, that his or her condition may result in injury. So again, there are many cases the agency must establish appellant's medical condition prevents him from being able to safely and efficiently perform the core duties of the positions. One such case is Clemens versus Department of Army, and that's the AJ. Okay, and another case is Elshoff versus Department of Interior. So a few cases. Case called Clemens. Communication was a core duty of a supervisory public safety dispatch position, and a stroke impairing speech warranted a medical inability to perform. Another case, which is cited earlier in your slides, Wren versus Department of Army, a significant amount of work-related travel as an engineering lead or a data lead on agency IT projects warranted removal of the individual who was unable to travel and was unable to deal with IT projects. And performing direct field observations on foot by letter carriers. I average 3 trips to a field a week, where the core duties of a supervisor or customs service person. So such a foot impairment limited her ability to work two hours a day, and there wasn't a reasonable accommodation. Those were core duties, essential functions, and justified because of their medical condition, a medical inability to perform. Another area which requires more time is excessive absence. So remember, when somebody is on approved leave under normal circumstances, you cannot take a disciplinary action against them. The only time you can take an action when you've actually approved leave is to basically give them what I like to call is if there is excessive absence. So in order to prove excessive absence, you must establish that the employee was absent for compelling reasons beyond their control, so that the agency approval or disapproval was immaterial because the employee could not be on the job, and 2, the absences continued beyond a reasonable time, and the agency warned the employee that an adverse action could be taken unless the employee became available for duty and the position needs to be filled. So in a excessive absence case, the way you deal with it is somebody's out, you've approved their leave. The first thing you remember, you must exhaust FEMLA before you take any of those actions. And then, if they're on approved absence, you need to give them what amounts to a cook letter. You need to say, you've been out for 8 months. The impact of you being out is to adversely affect the efficiency of the agency. If you continue to be out for an extended period of time, continue to be out, you may suffer from disciplinary action. If you don't provide that cook letter, if you don't provide that warning in advance, you will not prevail. And a recent case where that occurred is Savage versus Army, and I lead you to look at that. There are only 3 minutes that are left, and in our presentation, according to my watch anyway. And so what I want to do is address a couple of points. Number 1, general reevaluate your reasonable accommodation procedures. If you don't know them out there, you need to find them. Carefully train your managers, and carefully evaluate all your medical qualification standards, and carefully assess any decisions based on medical evidence involving medical inability to perform. The last thing I want to do, next slide, is to say to you there are important tools that you should familiarize yourself if you don't already know them. One is the CAP program, the Computerized Electronics Accommodation Program. If you don't know, you can reach an agreement with the CAP, which is part of DOD, and you can get free technology accommodations. They'll train your people for nothing. So that's the best deal in town. So if you don't already have that arrangement, you should call CAP and make that work. The next thing is the Job Accommodation Networks. The JAN program is an amazing tool. You can call them up if you're trying to figure out what an effective accommodation is, and you'll get an expert in that field who can brainstorm with you and work with you to address that. The other thing is, the critical part of all of this is when you are making decisions based on reasonable accommodation, you must be basing it on sound medical evidence. If you don't have a doctor in play in this process, you are vulnerable to the agency to losing that case. So if you don't have an agency doctor, you can call the Federal Occupational Health. You can enter into and call Dr. Neil Prezant. Hopefully he doesn't get 1,400 people calling him, but whatever. At any rate, but essentially, and this is the website that's on that last page, you can call them up and you can enter into an agreement, and they will provide the agency with medical assistance in evaluating reasonable accommodation requests. They're fantastic, they're helpful, and you really need to go there. The other thing is you should read the Bible, Unreasonable Accommodation, which is in this link, the 2002 enforcement guidance by the EEOC, Unreasonable Accommodation and Undue Hardship. The other thing is what I attached here is I was a facilitator of the White House Summit on Reasonable Accommodation and Disability in 2015, and there they handed out this amazing array of paraphernalia about all sorts of ranges of information that you would consider for reasonable accommodation, all sorts of guidances about the things. I strongly urge you to look at that link. And finally, if you haven't had enough, you can always go to my last request, or go to the YouTube page for OPM. I have done 3 or 4 other issues on accommodation. There are other disability-related presentations on there as well as others. I recommend that. And in closing, I think we are done. I leave you with a YouTube video on Disability Rights Tribute.
The communications team's telling me we can take one question if you're okay with that, Mark.
Oh, we can? Okay, that's fine. I have one question. Thank you.
Yes. So this question is a clarifying question from earlier.
Sure.
I can pull it up here. So the question is, given the concepts you talked about with commuting lengths and things like that, the question is hypothetical. If there's an example of an employee who lives 3 hours away from the office, a 6-hour round trip, and they're experiencing back problems and request a reasonable accommodation to telework because of that extra long commute, has the EEOC determined a specific point in which the commute may be too far to ever be considered a reasonable accommodation?
There's not any specific case law on that. And I think it would be based upon a number of factors. Number one is that it would depend on your medical condition, what's too far, what might be short for some of us could be too far for others. And number two is, it may be that there might be alternative accommodations like working at home or other things that would potentially be considered. But it's an individualized assessment. You would have to show that it's too far. Do we have time for the video? Great. So we're going to close with the video. It's been an honor and a privilege presenting to you, and I wish you the best. Thank you.
Over half a century ago, contralto Marian Anderson electrified America, singing on the steps of the Lincoln Memorial. In April of 1939, she hoped to perform here at Constitution Hall in Washington, D.C. But the Daughters of the American Revolution who owned the hall refused to suspend their Jim Crow policy barring black performers. When the facts became known, Eleanor Roosevelt publicly resigned from the DAR. A few weeks later, Marian Anderson accepted the Secretary of the Interior's invitation to perform instead on the steps of the Lincoln Memorial. It was a defining moment in the struggle for civil rights. I'm James DePriest, and Marian Anderson was my aunt. I grew up in a home full of 3 things: love, music, and dreams. Most of those dreams have been realized, and today I conduct orchestras around the world. But I never imagined that one day I'd become a person with a disability.
Okay, try.
At the age of 26, while conducting in Bangkok, Thailand, I contracted polio. Literally overnight, my world changed. Oh, I was still a young conductor with ambition, but suddenly walking was a challenge. Stairs loomed large, and concert halls without ramps were everywhere. As obstacles I'd never noticed before became a part of my daily life, I quickly learned that the intentional walls of discrimination and the physical barriers confronting people with disabilities have the same effect. Both deny access. 13 years after that historic Lincoln Memorial concert, the racial barriers came down here at Constitution Hall. But it took another 50 years for other barriers to fall, and it required an act of Congress to make it happen.
This historic act is the world's first comprehensive declaration of equality for people with disabilities. The first.
The Americans with Disabilities Act was signed by President Bush on the South Lawn of the White House on July 26, 1990. This landmark civil rights law gave people with disabilities the same legal rights that other minorities had fought so hard to achieve. Discrimination against people with disabilities is now illegal.
Mark, on behalf of Partnership and Labor Relations, thank you for sharing your expertise during today's roundtable on case law update and practical discussion on disability law and reasonable accommodation. Your presentation has provided outstanding and in-depth overview of disability law and reasonable accommodation. I thank OPM's communications staff as well for your webcast of this roundtable, and thanks to my colleagues in Partnership and Labor Relations for your work jointly on this roundtable. And thank you for participating today. We look forward to having you at the next Employee and Labor Relations Roundtable. Finally, please remember that shortly you will receive an email with a hyperlink to an online evaluation form courtesy of SurveyMonkey.com. Your feedback helps us to plan future roundtables, and we appreciate you taking the time to complete this survey. Have a great afternoon.